All right, one moment, please, and I'll get the record started. The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding. It is Tuesday, April 9, 2024 at 8:31 a.m. And this is for case 2015-1447 DS, Alexis Tabaka versus Christopher Tabaka. Attorney Elaine for defendant.
Good morning to all of you.
Good morning.
Morning.
I wanted to just clarify on the record, I did get, our office did, I didn't, but our office did get a call from Miss Elaine last week in which she informed us that she was withdrawing the motion to show cause for failure to pay attorney fees as they had been paid. She also informed us, Ms. Tabaka, that you were withdrawing your motion for attorney fees. Is that correct?
Yes, Your Honor.
Okay, thank you. So we are basically proceeding on the two motions to show cause in this matter. One filed by defendant, one filed by plaintiff. And maybe you could, I guess, tell me, I'm not certain now, I didn't have the dates as to which motion was filed first.
Ours was filed first, Your Honor.
I thought it was, you filed yours back in when, October, November?
October,
Okay.
Your Honor.
Okay. So we'll make you, Ms. Elaine, the moving party, at least in regard to that. So is there any preliminary matters before we commence, Ms. Elaine?
I don't believe so, Your Honor.
Okay. Ms. Tabaka?
No, sir.
Okay. Ms. Elaine, do you want me just to make an opening statement or proceed to your proofs?
I do, just a brief opening.
Okay.
Yeah, this court is familiar with the issues surrounding what I have called, through the history of the proceedings, the work parenting time provision of the parties' 2015 custody order. As a brief reminder, the parties designated parenting time so that if Alexis was working, Chris would be afforded that parenting time. And as this court will, I'm sure, recall from our first show cause hearing on this particular issue, everything had gone fine with that work parenting time provision until Alexis got angry with Chris in the summer of 2021 because he filed an ex parte order regarding contact with her boyfriend, which resulted in a no contact. And from that day forward, Alexis has done everything in her power to ensure that Chris does not get the children when she works, including violating the order repeatedly, and now to the extent of becoming voluntarily unemployed for a significant number of months so that she could not, so that she wasn't working, so that she would not have to give the children to Chris. It's really outrageous. It's a sad situation because she's punishing these children and keeping them away from their father for her own petty vengeance. Now, this court held a show cause hearing on the violations that we alleged, and an order entered on September 15, 2023, and awarded Chris 39.5 hours of makeup parenting time. The court also ordered that Alexis pay half the attorney fees for that proceeding, which she has now done. The subject of the last show cause hearing were violations of that work parenting time provision up through November 9th of 2022. And today's show cause involves her violations from that date up through June 23rd, 2023. And the reason for the gaps, I guess, is because by the time we got to the show cause hearing, there had been more violations. And then this hearing will encompass those that had occurred up until that hearing, and then those following that hearing up until June 23rd, 2023, which was essentially the end of her work with the Calhoun County Sheriff's Office. Notably, Your Honor, we deposed Alexis on August 12th, 2023. And at her deposition, I presented her with her timesheets, and I presented her with our spreadsheet, which is our exhibit A or B, A, I think today. That spreadsheet, what we claimed were the violations of the work parenting time provision, the dates and the times of those violations. And we went through every single date on that spreadsheet with Alexis at that deposition. And in short, and we have her deposition here today, she testified that the work hours listed on her timesheet were correct. So she validated all of those. And she testified that if the times we had identified on our spreadsheet were indeed her parenting time, then yes, she had violated the work parenting time provision by not allowing Chris to have the children. And we, after that deposition, Your Honor, tried to avoid this hearing. We tried to avoid taking up this court's time, and I'm saying this because I think it goes to the claim for attorney fees that we will make today. After the deposition, we sent a demand letter to Alexis's prior counsel demanding, essentially saying she admitted these violations, and this forms the foundation of our claim. And so we demand this makeup parenting time. We provided the timesheets, we provided the deposition references, etc. And we were denied that resolution and were forced to take this matter to court. So all in all, Your Honor, there are a couple errors in the timesheet that I'll go through just through the testimony, but at the end of the day, there are 53.5 hours of makeup parenting time that Mr. Tabaka is entitled to. And we would like this court to order that parenting time be made up to him in the following ways. He would like to select 3 to 10 hour blocks of parenting time. Just like the last time, he would provide 7 days notice of the dates that he wants this makeup parenting time to occur. And he would agree, just like last time, that he would not be able to choose and supersede any of Alexis's set holidays. We would also ask, Your Honor, just like last time, that attorney fees for this proceeding be awarded, which would include some of the deposition time, not all of it, but some of it spent on this piece, the efforts to settle, the show cause motion itself, this hearing, and a couple false start hearings that we've had up to this date. Thank you.
Okay, thank you. Mr. Baca, do you wish to make an opening statement, or you can reserve your opening statement, or you can waive your opening statement?
I'm not entirely sure how it works, Your Honor, but I'll make an opening statement.
Okay.
Just in regard to most of what Ms. Elaine has just said is not true, and it is meant to mislead this court. And I have all of the evidence that we'll be going over today, including much of what Ms. Elaine talked about. And in the deposition that she is referring to, I did not make those admissions that she's claiming to the court, but that can be read from the transcript. I certainly have not violated your order that you put in place on May 12th, and I think that you will find, Your Honor, that almost everything in their claim actually goes entirely against your rulings for that date, which I will go over with exhibits. And I also have several witnesses to testify on behalf of me regarding a lot of the false things that Attorney Elaine just presented to this court. So I don't enjoy this, but I'm ready and I'm prepared to provide the evidence to show that those are untrue claims, that this is a frivolous case being brought upon me just to harass me. I guess that's my opening statement, Your Honor. I apologize. It's not glamorous.
That's fine. Ms. Elaine, you can call your first witness.
Yes, Your Honor, I would ask that the court sequester any witnesses now that Ms. Tabaka has said that she has some. I don't know where they're located and they may not be with her, but just in case they are.
Okay. Ms. Tabaka, any response to the sequestration request?
No, sir. Everybody should be attending in over Zoom. There's just one person, and my mother is in my home, and I will let her know that there's a request for her to be sequestered. So give me just one moment so she knows to not be shot.
Okay, thank you.
All said. Thank you, Your Honor.
Okay, thank you. Court will grant the request for sequestration. The court will inform any of the witnesses that may be viewing this through Zoom or in any other manner that they are not to do so and are prohibited from doing so until such time as they have completed their testimony. And if I will state, in the event that a person does view these proceedings and we find out about that later, we could strike their testimony or they could be held in contempt of court. So with that, Ms. Elaine, you can call your first witness.
Thank you. I call Alexis Tabaka.
Okay. Ms. Tabaka, we'll have you raise your right hand and be sworn in.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
I do.
Thank you.
Go ahead.
Jesus, will you enable me to share my screen, please?
Yes, one moment. You should be able to do it now.
Thank you. Good morning, Ms. Tabaka.
Good morning.
Good morning. I'm going to show you what we have pre-marked as Defendant's Exhibit B. Just give me 1 second to get it up on my screen here.
My mother picked the kids up for me. Daniel doesn't get out of school until 3:40. I was out of work at 4, so I was home to receive the kids before my mother even got home with the kids. Let's see, 12/7/2022. They're claiming 2 hours. And this was a day that my mom picked the children up from school and wanted to take them out to dinner. So I just worked until my mom let me know they were on their way home from dinner. Tuesday, 12/13/22, they're claiming 2 hours. This again was a normal piano Tuesday, where the last piano lesson concludes at 4:30. And it takes my mom at least half an hour to get home. I ended work at 5, so we were home together about the same time. Friday, 12/16/22, they're claiming 1 hour. I worked till 3:30 that day. My daughter was at school until 5 p.m. because she had a school dance. And my son doesn't get out of school until 3:40. So I wasn't working really at all during a time that would be where there'd be parenting time to Chris there. Wednesday, 12/21/22, they're claiming 2 hours. On this day, Maddie and Daniel, they had math Olympiad and piano lessons after school. So I remained at work longer while they had their extracurricular activities, which their father actually participated in. And I was home when my children got home from those activities. Tuesday, 1/10/23, they're asking for 3 hours. All of the children had piano, which again concludes at 4:30. On this particular day, my mom wanted to take them to dinner, which she informed me, and so I just remained at work until they were done with dinner, and then I met them at home afterwards. On Friday, January 27/23, they're claiming a half an hour's time. I worked until 3:30 that day. Maddie gets out at 2:30. Daniel gets out at 3:40. So I'll just leave that. They're asking for a half an hour of time. It takes longer than that just to get to Marshall. Wednesday, February 1st, 2023, they're asking for 1.5 hours. I worked till 4:30. Maddie and Daniel, looks like Maddie had piano at 3:30, and then Daniel was picked up, I'm picking up Maddie at 4. They had piano until like 4 p.m. on that day. And again, it takes my mom at least 30 minutes to get home. I worked till 4:30. We were home about the same time. Friday, 2/3/23. They're claiming 30 minutes of time. I got out at 3:30, which is before Daniel even gets out of school, and that's an amount of time that's takes longer just to drive to Marshall and back. Wednesday, 2/15/23. They're claiming 1.5 hours. Says they work till 4:30. My mom picked the children up. Daniel gets out at 3:40. And so I left work like about the same time that they were coming home or getting home. Friday, 2/24/23. They're claiming 4 hours. This is the second date in their list where there was a bad snowstorm and all the schools were closed. And it was a Friday, which means that if Chris had even asked for the children, I would have had to travel on those dangerous roads to Marshall with the children and back, and then to Marshall and back, 2 round trips because it was my Friday, my weekend, and the children were already with me. On Wednesday, 3/1/23, they're claiming 1.5 hours. My mom picked up the kids, Daniel, who gets out the latest at 3:40, and I was home at approximately the same time that they arrived home with my mother that day. Wednesday, 3:15, they're claiming 1.5 hours. Again, same scenario. My mother picked the children up from school for me, Daniel getting out at 3:40. And then me getting home at the same time that they would get home with my mother. There was the Monday 4:10 that they have on this list, which of course I expressed in communication in August that Mondays aren't my days, and I don't know why it's on my list. Then Wednesday 4/12/23, they're asking for 1.5 hours. Same scenario as above. My mother's picking up the children for me. And then I leave work at approximately the amount of time it would take for her to get home and me to get home at the same time. On Tuesday, 4/18/23, they're claiming 2 hours. This was a day that all the children had piano lessons, which end at 4:30. And again, it takes my mother at least 30 minutes to get home after piano lessons. And I would have arrived home before or at the same time she was getting back with the kids. Friday, 4/21/23, they're claiming 1 hour. I worked till 4. My mom picked my son up. Daniel gets out last at 3:40. And so I was home before they got home from school pickup. Wednesday, 4/26/23, they're claiming 1 hour. Same scenario. I worked till 4. Daniel didn't get out of school till 3:40. So I was home before my mother got home with the kids. I don't know if I just said this one. 4/28. There's a bunch they have in April. 4/28, same scenario, claiming 1 hour. I got out at 4. Daniel was picked up by 3:40, and I was home before they got home with my mom. 5/5/23, they're claiming 1 hour. They got out at 4 p.m. So same scenario. My mom picks them up. I'm home before they even get home from pickup. Tuesday, 5/16/23, they're claiming 1 hour. And again, I was out by 4 and I was home before the children got home with my mother. And I do believe they added a date after that.
The father's attorney steps forward and lays out the core accusation. According to the defense, the custody order included a specific rule known as the work parenting time provision.
Yeah, 519, which, as I said before, I got out of work at 2 and I picked my kids up that day. So I'm not sure why that one is even on there. So that's my analysis and what I have gathered from, once I was able to actually sit down and review this spreadsheet that was provided by Attorney Elaine and go through the dates and correspond them to OFW communications and the children's calendar of events. I could break it down and see where all this time was. Most of these dates are on piano days where the children were in Marshall much later than normal. And my mother would facilitate the piano lessons because she's also a pianist. And I would always work it out so that I would be at home by the time my kids got home with my mom from those lessons. I tried to resolve a lot of all this entire motion for these hours with Attorney Elaine and Chris back in August. I had put together, and this is in my exhibit, and I'd like to read it if I may. It's an email that I wrote called Answer to Parenting Time.
Objection to hearsay.
I wrote it. Words, Miss Elaine, how is it hearsay?
Because it has to be offered against herself. If it's a party, the only way it can come in is if it's a party admission she's offering it against herself.
She can answer. I mean, she's giving testimony. She can give testimony as to what happened on these particular dates. So
right. At this point, it's a settlement negotiation. The whole email chain is labeled not admissible through MRE 408.
Mr. Baca, you can't testify as to settlement negotiations. You can
Your Honor, this
you can testify if you offered makeup parenting time, but you can't testify as to the negotiations.
Yes, sir. This was not an email pertaining to negotiations. This was an email of me breaking down everything that I just read in that spreadsheet. So, I mean, I could have written this again on a piece of paper to read to you today, but I figured I would just read it because I had it clearly written out in an email that I composed myself, not to Attorney Elaine.
Okay, go ahead.
Your Honor, though, still, she can testify, but it's not proper for her to read something into the record.
Well, Ms. Tabaki, you can testify about this, but you can't have documents that you're reading from that are not, again, exhibits or not in evidence, etc. So testify to what you want to testify to.
All right. When I reviewed the entire spreadsheet day by day and compared it with all of the calendars and took into account the outcome, of course, of the May 12th hearing that we had where you made rulings and decisions on the denied parenting time, on what the provision meant, on the specific hours that you did award Chris, on the hours that you did not award Chris, and on things that would not be considered, such as short periods of time that would be consumed by travel, and the where you ruled that Chris could be allowed to facilitate the activities after school moving forward. I considered that because they're
She says the father actually saw the children at school or activities anyway. But the attorney pushes back, arguing those moments don't count unless they were officially arranged under the work parenting time rule.
they're disregarding that ruling and using it retroactively. You didn't award those times where my mother helped me with the kids, but you did say that moving forward she couldn't do that. And despite them knowing that, they still included that in this motion against me, and they still included, I mean, most all of the dates that they provided to you. 31 and a half of those claims are for periods of time that are 2 hours or less. And also their tally of hours for all of the denied parenting time they're claiming in total did not add up to the 53 and a half that she claimed in her opening. I had to count it over and over to make sure I was correct, but there was actually only 48 hours in that spreadsheet that she gave me. So, and again, they threw in Mondays, which aren't my days at all. And I don't know if that was just to add hours to make it look like there was more time that I was denying that was actually factual. The total amount of makeup time in their list for periods of time over 2 hours came to 16 and a half hours of time. And 7.5 of those hours, Your Honor, were on those adverse weather days where the schools were closed. Chris didn't request to get the kids. He didn't request to drive on the bad roads to come and pick up the children. And they were already with me and would have been with me for the weekend. So that would have been 2 round trips on those dangerous roads, transporting the children. So, I mean, if you want to count those hours at 16 and a half, if we don't count those hours, it would have been less than 10 hours of makeup parenting time. And I believe specifically based off of your review of all the hours from the original hearing, Your Honor, I did remember that you did grant him parenting time for the days where I had prearranged family engagements, like with the grandparents or with the aunts. And so one of those days, the 6-hour day on November 23rd, where I had made plans with the children's Aunt Debbie and Aunt Denise to have a play date, I immediately offered up that time to the defendant back in August, of which, of course, that was refused. There was no interest to resolve. So I believe that I put forth very valid effort in trying to resolve this. And I did it based off of how you ruled on the hearing on May 12th. I remembered you said no periods of time that would be eaten up by transportation, short periods of time. And again, the piano and my mom was May 12th moving forward, and that's over half of what they have here. So this, Your Honor, is why I do consider it to be harassment, because I shared all of these facts with the defendant and his counsel for every single one of these dates. I said, but, you know, Judge Courtroom ruled no short periods of time, and that seems to be ignored. I mentioned, that the piano and my mother helping out was moving forward, and that didn't matter. That seems to be ignored as well.
Then Alexis begins walking the court through her own detailed breakdown of the accusations, date by date. She explains that many of the claimed violations involve extremely small time windows, sometimes just 1 hour, or even less.
And again, I did offer time, and it didn't matter. There's no desire to resolve the issue, because I think there's more of a desire to just keep me in court. So
Anything else, ma'am?
no, sir, that's all.
Okay. Ms. Elaine, any recross?
Yes, just a few. Ms. Tabaka, since you and Chris communicate through Our Family Wizard only, can you show us where you offered him the time on November 23rd, 2022?
No, because that was before the judge ruled that I needed to do that. Everything was May 12th forward.
Okay, I understand that piece, but you testified just a few moments ago that you immediately offered Chris the time on 11/23/2022. You said from the original hearing, the judge granted Chris parenting time when you had play dates lined up, and you had a play date lined up on 11/23/22, so you immediately offered Chris that time in August of 2022.
Yes, ma'am, I did, but you requested to Judge Kirkham that
No, I'm just asking where
this not be supplied. This is the email to you.
No, I'm asking you where you offer that up. So if it's the email, that's the answer, but that's what I'm trying to find out. Where did you offer?
Yeah, on August 30th, 2023, when I had counsel, my counsel provided all of that information that I just shared with the court in an email to you in an effort to resolve.
All right. So you said 2022 a few minutes ago. So you're talking about August 30th, 2023.
2023, August 30th.
And you're saying that Mr. Schaefer wrote an email to me, right?
Correct, because at that time I had counsel.
I know, so you're not saying that you told Chris that he could have the time, because this happened afterward. I'm trying to get clear because I wasn't clear. So you already had deprived him of the time on November 23rd, 2022, and then you're saying you acknowledged that at some point later, correct?
I'm saying that I had used my parenting time to facilitate a play date with the children's family that I did not know was later in May going to be considered something that I could not do. Because as far as I had known since the inception of the order, my parenting time is my parenting time, and if I want to use it for family building and the children getting to see their family, that's normal, common practice.
All right, I understand now. I thought you were trying to say that you had offered Chris the time on 11/23 and he had refused it, but I understand the timeline now. Can you point out to us where in Judge Kirkham's order he said anything about 2 hours or less?
I don't have that order in front of me. I recall him saying short periods of time, and especially those that would be eaten up by transportation, the time lost in transportation.
As the hearing begins winding down, the courtroom atmosphere remains tense. Alexis tells the judge she even attempted to resolve the dispute months earlier by offering make-up parenting time voluntarily. According to her testimony, those offers were rejected. Instead, the conflict continued escalating into another full court hearing. The attorney briefly questions her again, challenging her interpretation of the judge's earlier order and pointing out that some of the things Alexis claims were never written in the official ruling. That exchange highlights the core issue in the case, what the custody order actually requires, and how strictly it must be followed. With both sides firmly planted in their positions, The judge calls for a short recess before the next witness is brought forward. And at this point, it's clear this custody battle is far from over.